Yade mo boy remu straight to Accra High Court and sema ACC wo hono kwabena de Boahen e de nensa aguniti third prosecutional witness against kwabena Addo Boahen Mildred Donko abusua wa shocking High Court judges na abusua enensema wadri e de agu ono man na ye frɛ no kwabena Addo Boahen enisu ena ote ewo courtroom no aha gossip politics TV so unsubscribe ya subscribe na hit on the notification bell so na any update be able drop no onsa ebetumi akabi na maame a ye frɛ no Mildred Donko third prosecutional witness ensemben ena wadwiri ede agu court na ogina na daka ni mu a ama kwabena Addo Boahen otinisu on the lawyers tinisu esanso a shocking High Court judges eno ya project ede ato ye screen no enchen ede amam no kwabena Addo Boahen sent huge sums of monies from BNC accounts to friends and businesses, including proprietor of Alhaji's wife, Rashida Sani. Abusuya, according to third prosecutional witness, Ose kwabena Addo Boahen emane de sika twetwere die oyiska free ni BNC accounts. Ede command ne nanfofo ene business woman bi a ye friend hwan Alhaji wife Rashida Sani. Abusuya maame ne nsɛm a ɔka no ɔpɛsɛ ɔkyerɛ ɔtestify kyerɛ sɛ no kura trudo sika kwabena Addo Boahen ne fae no National Signal Bureau for sika ɛnyɛ ɔno ane sika na withdrawals a ɔno kwabena Addo Boahen ma no yɛɛyɛ no abusua ɛnyɛ no nko a I was given pre-signed check to withdraw and transfer various sums of money to former National Signal Bureau director kwabena Addo Boahen's companies Mildred Donko, according to Mildred Donko. Enti utie maame ne nsɛm a ɔka no ene ɛwɔ court na kwabena Addo Boahen baabi a ɔde n'asɛm ne bɛfa bia enye yi because maame ne ka no kora bia ɛwɔ mu bia ɔde check ne ma no according to prosecutional witness no money transfers bia o money na che se kwabena Addo Boahen ne money transfer bia na oye free National Signal Bureau bia ma me no o money ye ma no abusia kwabena Addo Boahen ne ho akire no enti no ene ye kopie mu e wo court no the alleged 49.1 billion Ghana cedis National Signal Bureau sika kwabena Addo Boahen transfer kogu ono ane personal account eno ho nsem na kyerɛ third prosecutional witness no or the betu dwa edma na High Court ho na nso no maame a ye frɛ no former Chief Justice Tokonu moten nka ache case bi a court no ono nso nensem aba bepie mu ewo High Court mom yenko na yenkonkotie ensem a ene court no ede etudwa former Chief Justice Tokonu ni case and kwabena Addo Boahen ono nso case no eno ene ya project ede ato ye screen no enchen ede ya mamon unsubscribe ya subscribe na hit on the notification bell so na be any update be drop no onso onsa ebetumi akabi medamase.
What she's about to say. When she said she's okay,
it's okay.
She's okay.
Well, what do you have? What happened in court yesterday?
Yesterday you told us the Supreme Court was going to get busy.
Yes, and it did. It was busy. Yesterday I left.
The Supreme Court was busy.
Very busy.
My boss and my colleagues, my senior and my colleagues were there since morning.
Yeah.
They left the Supreme Court at about after.
There was later. They left after 2
because
their case was dealt with then. The one that I was also we're waiting for the former Chief Justice case. In fact,
you know
was
why?
The last
because a justice of the High Court.
Yes, Justice Ellen. Yesterday
yesterday.
So the day before, the one who passed. So the day before
all
was
the
her
cases.
funeral. So all the cases of the Supreme Court didn't sit.
Yes.
Yes. So the cases that were supposed to be heard that day were moved to yesterday. Yeah.
So yesterday was
May her soul rest in peace.
I mean, absolutely. It was really a packed Supreme Court, and it was packed because of the cases that were coming, like Sewa mentioned. On the yesterday was Wednesday, so the cases that were supposed to happen on Tuesday, all of them were migrated to Wednesday. And let's have the visuals of the former Chief Justice. We're talking about the former Chief Justice. Yesterday, the Supreme Court almost ended the sitting almost around 3:30, almost 4 p.m. And cases that has to do with the former Chief Justice, Gertrude Saki-Tokono, 4 different cases yesterday came up at the Supreme Court. And 4 different cases, somebody will ask, is she the one filing all the 4 cases? No. So for those who remember, when the issues of the suspension started, then her removal, I mean the suspension, when the committee was put in place to investigate into the allegations made in those petitions, the Vincent Assefuah, Member of Parliament for Otafo first, went to the Supreme Court. He was challenging the manner, the processes, and the issue of Article 146 and its related provisions came about and all of that. So you note that there was a leg of an interlocutory injunction which the Supreme Court dismissed. On top, beyond the interlocutory injunction, there was a substantive matter that he was asking or challenging constitutional provisions to say that the manner in which her removal, her suspension was done was unconstitutional. So the substantive matter was pending. That did not end there. A citizenship, constitutional, and electoral system led by Kwabena Bonfe, Kabila, popularly known as Kabila. They also filed a similar one, also challenging the manner in which the former CJ was suspended at the time and subsequently removed. They also went with an interlocutory injunction. That one was also dismissed. Then there was a private citizen, Theodore Kofi Athakorte, who also went to the Supreme Court, also in the same manner. He also had an interlocutory injunction, which was also dismissed. Then the former CJ herself, at the time when she was going through the processes, then she filed an action at the Supreme Court. On top of that was also an interlocutory injunction. And she made an appearance at the Supreme Court, and that was the first time that she made that appearance. And remember that there were certain things that she stated in that interlocutory injunction, i.e., to bring in things that were happening to her within the committee sitting, which the Supreme Court even struck out before hearing the interlocutory injunction. And at the end, the injunction was dismissed. So once all the interlocutory applications have been dealt with, then the substantive matters are pending. So yesterday, for the first time, all these 4 cases that I have mentioned and the applicants who were involved were called at the Supreme Court, and Justice Amadou Tanko was the one presiding. In relation to the one filed by the Citizenship, Constitutional, and Electoral System, they were asking, there was another application that they were asking the court for an opportunity to amend their relief, one of their reliefs. The Supreme Court looked at it, and yesterday, they as applicants were not present in court. It was only the Deputy Attorney General who was representing the defendant in the matter, and they sued the Attorney General and all of that, the Chief Justice herself, and then Justice Boahen, who was leading the committee. So yesterday, Dr. Justice Sh0ćks represented the Attorney General and Justice Gabriel Boahen. The former CJ was absent, and then her lawyers were also absent. The court make the point that hearing notices should be sent to, in fact, in respect of the census case, the one by Kabila, hearing notices should be sent to the parties and let them know that on the 14th of May, there will be a case management conference. That's an integral part of how this matter will be dealt with and all of that. And a memorandum of issues will also be looked at, and the court then would settle on the issues that should be set out for trial or hearing and all of that. So that leg of the case yesterday was adjourned. Then the leg of the case filed by Vincent Assefuah, yesterday he was personally also absent. His lawyers were also absent. Again, Deputy Attorney General Dr. Sh0ćks represented the Republic or the AG, because this action was against the AG. What the court note was that in all these cases, hearing notices were sent to these plaintiffs in the matter. And then so there was a proof of service on them that the case was coming up yesterday, but they didn't show up. At one point in time, the panel had issues with the fact that cases come before the court. The very people who filed their cases in court will not come. And then they will tend to blame the Supreme Court of delaying cases and all of that. That leg of the case has also been adjourned to May 14. The court is saying that hearing notice should be sent to the parties in relation to this one. Then Theodore Atakorte, his action too was also adjourned to the 14th of May. Then the former CJ herself, her own case, yesterday, like I said, she was personally not present in court and all of that. So all these cases have been adjourned to the 14th of May for case management conference, but the court has directed that hearing notices be served on all them personally or through their lawyers in relation to this one. So 14th,
okay.
We'll know more.
And yesterday you mentioned the suit that has been filed by Nyahota Maklo, Professor Frimpong Boahen, and the lady, basically on the political parties and how they elect their flag bearers.
Absolutely. Director, let's have the video. So yesterday, Professor Frimpong Boahen was present at the Supreme Court. Dr. Nyahota Maklo, so that's Dr. Nyahota Maklo on your screen, and Professor Frimpong Boahen. So yes, they filed the action. For them, the Supreme Court was happy that they came to court and they were present. So the Supreme Court makes the point that they have shown respect to the court by way of the fact, and senior citizens, you like to call it. So that was the moment have interaction with their lawyer, Oliver Barker-Vormawor. But yesterday, when the case was called, really, this is the case that they are challenging the internal electoral processes or internal processes of the NDC, NPP, CPP, and then they've sued the Electoral Commission as well and all of that. They are saying that, look, the part where you'll be electing the presidential candidate, then you allow one or two people to go and vote, decide who should be, and at the end, whoever you choose has the potential of becoming the president of Ghana. Few people cannot determine for that large number of people and all of that. So you have to change the manner in which you do your internal election and processes to conform with what Article 55(5) of the 1992 Constitution says, which has to be democratic in nature. So they went to the court and they actually, yesterday, the parties themselves, as officials from the parties, were not present. The Supreme Court had an issue that Justice Amadou Tanko specifically was saying that these political parties appear not to be serious with us, both those in government and those in opposition and those who even come to government. They are not serious, apart from the CPP. The CPP was represented. So the court, on a lighter note, make that particular point and all of that. So what the court has decided now, in fact, the parties in the case have to apologize to the court for not complying with the directive to file their processes and all of that. So at the end, it's been an adjourned sine day, but the respondents have been given 14 days to file their processes and all of that. But first, let's hear from Oliver Barker-Vormawor, who is lawyer for the plaintiffs.
First of all, we are grateful to the court for fixing the matter for today. We are grateful that the court gave audience to our clients in this matter. As you are aware, the substance of our client's case is that our political parties must be organized democratically. And what that means is that every member in good standing of those parties must have a say in the choice of who becomes flag bearer or becomes parliamentary candidate in those parties. We think that that aligns with the constitutional ethos that every person must be able to participate fairly within the processes that establishes a democracy. Now, the court's direction was to the defendants in the matter, which is the New Patriotic Party, the National Democratic Congress, the Convention People's Party, and the Attorney General, directing them within 14 days to file their responses to an action that was filed on the 26th of January. We are grateful for the court's benevolence. Usually the court will proceed without them, but I think that they themselves appreciate the court's grace in allowing them time to be able to file their responses to this.
Yeah, so that is Oliver Barker-Vormawor giving us some perspective on the case that they have filed before the court. But on the point really about some of the judges not happy about the fact that the political parties in this particular case are not serious. Let's hear from Oliver.
Before we entered court, the Deputy Attorney General was telling me that this case has the potential to be the biggest case that has happened in the life of the Fourth Republic. And I tend to agree. And we're hoping that the other parties also want to recognize the history-making nature of the case that has been put before the court. Certainly, it seems from the demeanor of the court that the court appreciates the constitutional issues that have been raised in this matter. And we trust that the parties themselves would attend and show the same level of seriousness to the matter. So by the natural processes of the matter, once they have filed the arguments, together the parties must come and generate what we call the memorandum of issues, which are what are the specific questions we are putting to the court for the court to answer. And then the court will give a date for us to be able to appear. And I must say as well that, even in terms of the nature of the composition of the plaintiffs that have come before the court, I certainly, I'm humbled by the different personalities themselves. These are persons who have served this republic at great length and are concerned about the future and the health of our democracy. And I'm taking this action in spiritedness. And I think that we want all the public to support and also be interested in the matter.
So 14 days from yesterday, the court will now fix a date. So the case has been adjourned since a day. Yesterday when I was here, I was telling you about the fact that the Supreme Court will be delivering a judgment, and that judgment has to do with, that when you commit an electoral offense and you are convicted and sentenced, after 5 years later or 5 years on ahead of you, you cannot vote. So this human rights activist is a lawyer, Fred Akwete, went to the Supreme Court to challenge that provision and say that that is unconstitutional. As long as you are 18, you have sound mind and you can vote. Once you have been convicted, sentenced, you finish serving, you should be allowed to vote. Yesterday, the Supreme Court unanimously dismissed that as unmeritorious. We spoke to him moments after.
It's surprising, just waiting for the judgment to see the reasons behind the judgment. The representation of the People's Law, which is PNDC Law 284, has certain provisions which provided that once you commit certain electoral offenses, for example, you snatch a ballot box at an election, after you've been convicted and you've served your sentence for the next 5 years, you cannot vote. And our argument is simple. The Constitution guarantees the right to vote and provides that once you are 18, a Ghanaian and of sound mind, you have the right to vote. But in this instance, where the right to vote is being denied as a form of punishment, it goes beyond the constitutional limitations, which are three for us, which is age, 18, Ghanaian citizen, and sound mind. So then once a person meets these three criteria, then you cannot deny the person the right to vote, even if the person has committed offenses, because the Supreme Court had years ago even decided that persons who are in prisons have the right to vote, because once they are 18 of sound mind and Ghanaian, you cannot deny them the right to vote because the prisons weren't a place of residence for them. When we see it depends on my lawyer, when we see the judgment and the reasons behind the judgment. I've not seen the reasons behind the judgment, so it's either the court will see maybe this matter has already been determined in previous cases, so they don't want to go into it again. So there are reasons behind the judgment which will inform us.
So all that the Supreme Court is saying is that once you have been convicted and sentenced for an electoral offense, the next 5 years after your sentence, you cannot vote. And that is what he was challenging. Yesterday, unanimously, the action was dismissed. The reasoning, the court says that it should be ready on or before the 5th of May. So that is with respect to this very well. Wesley girls.
Yeah.
So the squad, so you see on your screens, that's the president of the Ghana Bar Association, Ifwagati. Yeah. She is a board member of Wesley Girls. And she's the lawyer that is represented on the Wesley board, Wesley Girls School Board. And that is Abdulaziz Gomda, lawyer for the applicant. Yesterday, the Supreme Court sat on this matter, and an application came before the court, and the application was from the Board of Governors. In fact, Shafiq Osman is the applicant, the Board of Governors first defendant, Ghana Education Service second defendant, then the Attorney General is the third defendant. So the first defendant, which is the Board of Governors, say that they do not have capacity, they don't have locals to sue and be sued, so you cannot sue them. And they note that out of the 8 reliefs being sought, 6 declarations were geared toward them. The court should make a declaration that binds them, that affects them. And they say that we don't have capacity. We are a faith-based institution, and we are not like any other public institution that their board are all of that. And the issue of the Achimota School Board also came to the fore in the Rastafarians, where the court had made a decision that they are a legal entity, they have capacity to sue and be sued, so they represented in that case. They say that their case is special from Achimota School and all of that. So the court should take them out, and not take them out as it. They should dismiss the action in its entirety. But the plaintiff responded and said that, look, even if, let's assume that we are taking you out, the other relief that is binding on, that is seeking declaration on the Ghana Education Service, and if it is granted, the directive and the guidelines that the GES will make, who will implement it? It is the school. So why should the school go and fold its hands and sit down and say that we don't care, or we shouldn't be made part of this whole matter? Then, on the back of that, he said the request should be dismissed. Deputy Attorney General Dr. Sh0ćks also came in and said, look, he represented the GES and the Attorney General, and makes the point that, look, this is an error. The application is based on an error, because you cannot assume that GES is the one that is giving you that mandate to constitute the board. So whatever you do has legal basis, has some authority behind it. So the court should make them part of that action before the Supreme Court. So the panel presided over by the Chief Justice looked at it and said, look, the Board of Governors of Wesley Girls, you are a competent party to be part of this action. So that your request is dismissed. They have been given 14 days or 2 weeks to file their processes, and then the Supreme Court would then fix the date for the hearing to be done. But there was another application which the Methodist Secretariat was asking to, they filed an amicus brief without leave of the court. They had to withdraw that particular action yesterday. So yesterday, the Board of Governors of Wesley Girls School, their action to have the action struck out was rather dismissed. Let's hear from Abdulaziz Gomda, who represents the plaintiff.
It was very obvious that that would have been the conclusion to reach, because if you look at the complaint of the plaintiff and the reliefs the plaintiff is seeking, it borders primarily on the management of the school, and the law is very clear as to which body is responsible for managing pre-tertiary institutions like Wesley Girls. And the case law has been very emphatic on the position of Board of Governors, and I, for sure, was never in doubt that this was going to be the conclusion.
So, Abdulaziz Gomda, he is the plaintiff for the applicant, Shafiq Osman, here. So, 14 days after, the school will file their processes, and then they will be back in court and all of that. So, when I say the Supreme Court was busy yesterday, it was really, really busy. And one of the things that the Apex Court really did was that they took turns to commend the Deputy Attorney General, Dr. Justice Sh0ćks, for his activeness, for the manner in which he's always active, punctual at the Supreme Court to deal with the cases, how he takes the cases seriously and all of that. And they urge him to continue. When he becomes an Attorney General, he shouldn't sit in the office. He should come to the court that he's doing now. So it was one of the things that yesterday, he sat through the Supreme Court from the morning to almost after 3 when the Supreme Court ended the cases and all of that. So those were the cases that happened yesterday.
Okay.
And today, to me, that one that has to do with the Tanon Imre Forest Reserve. It's back on with the first prosecution witness. That is his former general manager for Akunta Mining, Edward Okuokun, to continue with his testimony or evidence in chief in the court. So this is the case that we should keep an eye on. And
absolutely. Mutala, thank you so much.
Okay, I was waiting and some course so our political highway. So I have Kwabena Addo Boahen and HSA. I didn't want some a brema any easy cry. But I must say, some of Japan cocoties are in some way at the MI. Aha, I have gossip politics TV. So, Madam, I say.